I want to turn away from the... Can I also just double check something on the full matter? You were not involved in the actual preparation of in the running of the case. You attended a consultation with Advocate Motemela and you subsequently attended consultations with Advocate Halgren. Is that correct?
That is correct.
You did not consult with Advocate Matau?
No, I did not consult with Advocate Matau.
Your contribution to the record was the reasons that I... Is that correct?
That is correct, Chairperson.
You were provided with a draft affidavit which you considered and you then signed, and that was filed at court. Is that correct?
Yes, that is correct, Chairperson.
Okay. Now, at some point you were charged in a disciplinary hearing on various counts of misconduct, including leaking of information and dishonesty. You raised one of those yesterday, and I just want to make sure that I had it. (16) of folder J. Not sure if this is the correct one. No, this is not the correct one, sorry. Advocate Mokgoro, we're talking about the one that post your affidavit in the, shall we call it Celebi matter? Let's just deal with it in the Celebi matter, right? And as I understand it, I simply just want to get the sequence right. The hearing commenced, you raised certain points in limine. It was scheduled to take place and you then brought an urgent interdict.
Yes.
Right? But you had also referred the matter to the bargaining council as an unfair labor practice dispute, claiming unfair conduct in respect of a protected disclosure.
Quite correct.
So the matter was then removed from the roll on the basis of lack of urgency. It then got set back on the roll and was pending at the time when a settlement was reached. The protected disclosure component in the labor court never went to fruition on the merits because you guys settled.
The position, if I may explain like this, the position is that after I sent the matter to bargaining council, I at the same time lodged an application with the labor court for an interdict. But before that application in the labor court could be finalized, the bargaining council had in the meantime issued a determination that they don't have jurisdiction over protected disclosure. Then I lodged another application later on. And then that application, I think the judgment in the interim order was sometime in May or April 2009.
My point was there were two applications before the labor court. One for the interdict, which you got interim relief on, and the other one was to adjudicate the question that it was a protected disclosure. They couldn't take steps against you.
Yes.
That application was pending, and that is in respect of which settlement was reached.
Yes.
Right. You were on suspension for quite a considerable period of time, probably about 20 months.
I was actually on special leave.
Special leave, let's call them special leave, right? That's correct. In the meantime, you had also transferred from KZN back to Pretoria.
Yes.
Around the same period. The dates don't matter because it's in your CV. I just want to get the timing right.
Yes.
Right? And in fact, that move was probably regarded as part and parcel of your settlement, if I seem to remember the documents correctly.
Not really. It's because by that time the Scorpions has been closed, so we're given a choice to choose to go wherever one would have chosen to go.
Right. Now, I'm battling, and I want you to help me out here. Your first meeting that you explain is the meeting on the Browsmill report where Advocate Piccoli tells you, everybody, please cooperate, and you know nothing about the Browsmill report. Right? You then get contacted, you get told that you implicated in this Browsmall report of which you know nothing about, and your office seems to be implicated. And they provide you with this information which you then say you were able to refute,
Quite correct.
right? And they then go away and they say, well, you're not implicated in the Browsmall report anymore. Is that how I understand the first part to be played off?
There was no such determination. They went away as part of their investigation.
Right. And those were, as I understand, that was Arthur Fraser from the NIA, somebody called Commissioner Lala, and the third person name eludes me now.
Mr. Jafta.
Mr. Jafta. That's right. Right? The commonality on the next approach that comes to you is it's that same people come back to you to tell you, we want to know from you what went on at the meeting of the 25th of July.
Yes.
Now, I don't get the connection between Browsmall and the 25th of July.
I also suggested to them I don't get the connection at the time. So I was convinced, I was told that because the investigation on the Browsmall is broad, is in relation to the intentions of the DSO acting within its mandate. So I was convinced at the end that indeed there was a connection. Well, and then thereafter I was requested to make the affidavit.
And you don't go back to, is Piccoli still there? I'm not sure if Piccoli's still there. But you don't go back to anybody and say,
no, a chairperson, you must understand this. This was an investigation conducted by the National Security Council. It was a top secret investigation.
into the Browsmall.
Into the Browsmall, yes.
But on the face of it, there doesn't appear to be any connection between what they asked you to do and the Browsmall.
That's what I thought initially, but I was convinced.
Now, what convinced you?
I can't recall what they said, but it was to the effect that because the Browsmall was about the NPA, the DSO acting beyond its mandate, trying to achieve political objectives and things to the effect that this meeting also was along the same lines, That was about it. I can't recall, but we had a discussion about this.
And you give them this affidavit, which you think is going to be dealt with as top secret because that's what they tell you.
Yes.
And you never expected to see the light of day until you discovered it's being used in the Celebi trial.
That's why I was comfortable even to give, because I asked for the assurance. I was assured this investigation is authorized at the presidency level, because the National Security Council sits in the office of the presidency at the time. So I was very comfortable that at least I've got the protection.
And it didn't dawn on you that you needed consent under Section 42 to make this affidavit.
I do not know whether I would have been defeating the ends of, because the investigation was against the very same organization. That is the problem that I had. So I would be accused of defeating the investigations.
Was the investigation into the NDPP as well?
It was the investigation into the DSO, the activities of the DSO.
But under Section 42, you need the consent of the NDPP.
In a sense, Advocate Piccoli had given that we must cooperate with the investigation. That was the bottom line for me. Advocate Piccoli instructed specifically that everybody must cooperate with this investigation.
So in your mind, you were doing this essentially with the consent of the boss?
Well, essentially, and partly because it was a top secret investigation. So if I go and tell people this is what these people are doing, and this, so it would have put me in a difficult position.
Now, this information you gave them on the face of it in the affidavit doesn't appear to be anything but a factual account of your version of what occurred at that meeting, correct?
That was important to, that's why they said I must give. That's information they wanted. To them, it was important. It was going to advance their investigations.
But it didn't show that a criminal offense was being committed.
I'm not so sure about that, whether the intention was to investigate a criminal offense or was to investigate breaches of the law, breaches of the Constitution, or something
Not the investigation, your affidavit. Your affidavit does not reflect a criminal offense that had been committed. Subject matter of your investigation.
Which affidavit? I'm a bit
Your
confused.
account of the meeting of the 25th of July.
No. It was just an account of the meeting. It does not.
I want to run, it doesn't show that a criminal offense has been committed or likely to be committed.
The matter that was under investigation
So
concerned.
we know what the matter was under investigation. I just want
Yeah,
you
yeah.
to answer the question whether, to the best of your recollection, whether that was what your affidavit showed or not.
It did not show the breach or the commission of a criminal offense, but it certainly showed the breach of the law.
Which law?
The DSO was established in terms of the law to advance certain objectives. The DSO is seen in terms of this to be acting outside that, influenced by political motives, something like that. So it was definitely showing, it might not have been showing a criminal offense, but it was showing that the DSO at the time was acting outside its mandate.
And did you regard that meeting to be an indication that they were acting outside of their mandate?
No. It was not for me to decide. This is what they told me.
You must understand my question. You do this affidavit, you draft this affidavit. Does the contents of your affidavit show a criminal offense?
No, it does not. I said it does not.
Does the contents of your affidavit show a failure of a legal obligation or a miscarriage of justice?
Absolutely. It showed that the DSO was acting outside its mandate in terms of its constitutive legislation.
And so what bothered me about this was when you claimed it to be in a protected disclosure, given that you thought that this affidavit was never going to see the light of day, how did it become a protected disclosure?
Because I thought like that as well. But for some reason, it saw the light of the day, and then I got victimized for that.
So it's an ex post facto protected disclosure, not a protected disclosure at the time you made the affidavit.
Unfortunately, the court agreed with my position. The Labour Court agreed with my position.
We can debate the Labour Court judgment and the law in argument. I'm trying to ascertain what was your thinking at the time that it was a protected disclosure.
I was giving that information hoping that I will not be exposed. Now that I was exposed, obviously I had to be protected because I gave that information in confidence as part of a lawfully authorized investigation. Now I find myself in this situation.
I don't understand, sorry to do this. Was the information, or were you given an undertaking that the information would not be disclosed, or was the information covered by the provisions of protected disclosure?
I was given, Chairperson,
Just an undertaking that this is done in confidence, we will not disclose it. It was not that. Legally, it was protected information.
I gave that information under strict confidence that it would not have been disclosed. But if it happened to be disclosed, obviously it must be covered by protected disclosure. That was my view. In fact, that was the view of the court. That was the view also of the court as well, of the Labour Court.
And the circumstances of that affidavit was very different to the circumstances of the next affidavit you gave in respect of your colleague, Advocate Gerinel. Is that not so? You testified that a police officer, Mabula, came to you from Gauteng.
Yes.
Now, how did a police officer from Gauteng in an investigation in Gauteng come to you in KZN asking you for an affidavit on how the DSO operates?
Excuse me. I would not know about that, but I was called over the phone and to say that they want clarification. I do not know. I remember asking, why don't you get this information from people close by, like your people in Gauteng office? I do not recall the answer. I can't recall the answer, but they requested that they would want to come and take that affidavit. It was made clear that it was more of procedural in nature.
And again, you got no consent under Section 42 to do that affidavit.
No, I was not disclosing any confidential information. I was not disclosing any secrets of the NPA. I was not disclosing anything that was supposed not to be known.
You were disclosing how the Scorpions operate.
No, the procedure.
In that you passed a remark that in the Shavangu matter, in my experience, your experience in the DSO, the responses of Advocate Nel, where he seems to suggest that he was never made to believe that the officials of MEEC were implicated in any irregularities, are outrageous and hard to believe in the light of what you stated, quote unquote. Surely you would only have come to that kind of knowledge in the course and scope of your employment.
Advocate Bauer, I'm saying that information is not information that concerns the secret. It's not a secretive information. It's not information that could not be known. I was comfortable that I was not disclosing information that is secret, that is concerns an ongoing investigation, that concerns an ongoing prosecution. It was information about procedures. We used to talk about those if we go to our conferences, in our outreach programs. We would tell the public how the Scorpions operate. We'll tell you this is how we operate. For example, if we have got to institute an investigation, we'll go through a certain section 2813. A preliminary investigation, all those processes, our searches, it is information that we use to share with the general members of the public.
You will accept that Section 41(6) says no person shall, without the permission of the National Director or person authorized in writing by the National Director, disclose to any other person any information which came to his or her knowledge in the performance of his or her functions in terms of this Act or in any other law. There's no requirement about secrecy.
I think I clarified this, Advocate Bauer. But I'm not so sure, Advocate Bauer, whether now I give you answers, I clarify them, you seem not to be satisfied. I don't know whether now I'm in the position of an accused person. You are a prosecutor now in these proceedings. I don't refuse to answer you, but I'm very concerned about your attitude, to be honest. You have become a prosecutor now, not an evidence leader. I thought you were supposed to lead evidence and clarify issues. I'm not refusing to, but I don't know whether you want your idea is to discredit me or to do what, but in any event, that's fine.
I apologize if you get that impression. It's a long day and I'm 15 minutes from wanting to get done. So I want to get through this maybe a little bit too quickly. So it's coming across unintended.
Yes, you're coming across as a prosecutor.
I apologize to do that.
Prosecutor now.
And I think all that we need is to establish the truth, is to hear what the truth is. We are going to write a report and analyze the information, and we would want to separate the truth from that which might not be the truth. So as soon as you establish the truth, I think let's move on.
Thank you, Chairperson.
As a consequences of your initial statement, not the Gerdinel one, the one in the Celebi matter, those Labour Court matters were settled essentially at the same time Advocate Jiba's Labour Court matter was settled. Isn't that so?
I would not know because my matter was in Durban, her matter was in
Okay.
Johannesburg. I don't have ideas in terms of when her matter was settled, when mine was settled.
You and Advocate Jiba go quite a way back. You're quite good friends. In fact, Advocate Breitenbach seemed to accuse you of hanging around the SCCU offices a bit too often.
Advocate Jiwa is an old-time colleague of mine. We all come from the Eastern Cape. We came together to Pretoria, were the first few black figures within the OZIO office, and we've been together for a very long time. The issue about Advocate Breitenbach hanging together as she described, I think it's not correct. I don't know where she got that.
Can I take you to, I want to deal very quickly with the OECD matter.
Yes.
Yes. You kindly handed up the Transparency International report. So, as I understand it, and the structures within the NPA is never quite clear to me, you have an anti-corruption task team, and the prosecutions for those task teams get done through the SCCUs. Is that how it works?
That is correct.
So, I'm not sure whether this goes back to Mr. Hofmeyer's complaint or whether this is a different complaint. But on page 21, and I'll just read it to you, of the Transparency International report, it reads, 41 of the anti-corruption task team's 42 successful domestic corruption cases ended with plea bargains and reduced sentences, raising concerns about the ease with which settlements and plea bargain arrangements are entered into. Do you agree with that?
To the extent that is mentioned as part of Transparency International report, I don't have a problem in terms of that information. But to the extent that it relates to OECD matters, it's incorrect. Those matters have got nothing to do with OECD.
Sorry, it doesn't relate to OECD matters, but in the course of considering transparency in the report provided on page 21, they look at various issues such as settlements, mutual legal assistance. They have various criteria which they look at: availability of enforcement data and case information. This is under E, where they deal with this in the report.
Yes, let me respond to you in relation to those 41 cases. The position is quite correct. I'm one of the people who had a big fight with Mr. Hofmeyer about that, and I became unpopular. The ACTT, the Anti-Corruption Task Team, is a body which was set up sort of in a way to bridge the gap between the dissolution of the Scorpions, to have that body to take that position in a sense. We thought it was going to be a body to deal with serious, complex, and high-profile corruption matters, both in the private and public sector. In terms of that, we're required to complete certain amount of prosecutions and convictions by a certain period. Some of those matters that are there are matters that have not been, I'm sorry that I have to say this in the public space, are not matters that fell within the ambit of the ACTT. Those were ordinary matters that were would have been with other units of the police, various units of the police, like your organized crime unit of the police. They would be with, some were with the tax unit. It's not the matters that were dealt with by the ACTT. So to have included them as part of those matters by the ACTT was, strictly speaking, incorrect.
And was that corrected in the public domain? Because it looks bad.
We have reported about that in Parliament. We have told Parliament about that. To the extent, I'm sure, because those cases start from the anti-corruption task team was put in place in 2010. Yes, in 2010. And we have been making presentations on those matters in Parliament. Let me tell you this, the difficulty is always this. These matters take very, very long time to investigate and prosecute. So the temptation was always to look for what we used to call quick wins, so that we can go and report some successes, which is not very, in my view, it's not a very honest way to deal with issues. We should rather report. If we can't do something, let's rather be honest and say, because of these reasons, it's something that we cannot do. You know, instead of giving incorrect or misleading information. But we have explained our position in Parliament several times. That is in the public domain.
It is that very danger that you highlight, Advocate Mokgoro, that makes it not always satisfactory to look at statistics, just at statistics in isolation, because it's the underlying rationale of those statistics that become important as to check at what the value of those statistics are. Wouldn't you agree?
Unfortunately, yes, I agree. We are in a government environment. You are evaluated on performance. So if you don't produce something, that was one of the problems that we have, because statistics on its own is not an indicator that you are doing what is right. You are doing what has got the impact, you know. So for example, I agree with you.
But what does come out of the Transparency International report in page 10, there's a table of investigations and cases from 2014 to 2017. And when you look at investigations commenced, weight of 1 for South Africa, you see 15 commenced in 2014, and then we have 0 right through till 2017. Do you see that?
You are talking about?
I'm talking about page 10 of the Transparency report of investigations having commenced in South Africa based on the limited enforcement of 11 countries, the criteria that they look at. And they see South Africa doing well in 15 with the cases that have been commenced in 2014, and in the next 3 years, nothing. And the reason why I raised it is because this actually substantiates the evidence of Chris McAdam. Don't you agree?
No, I don't agree. I don't agree. Let me tell you the position with OECD cases. I think I mentioned this in my evidence to say, problem with OECD has always been that South Africa is not showing sufficient progress in as far as detection, investigation and prosecution of foreign bribery cases. Most of their cases have not advanced beyond a preliminary stage. They are always, because the reports have always been that the cases are under investigation, Sorry. So that was the problem that we had. Detection of cases is a responsibility of the investigators. It is also the responsibility of the prosecutors in the context of the OECD bribery offense. The problem that we had when Mr. McAdams was there was that he was assigned as the sole prosecutor for those matters. And the effect of that is that it was not very easy to detect those cases, because you will never know whether a case is a foreign bribery case unless you have actually received the docket, you have perused the evidence, you have analyzed the matter. So to leave that task to one person was self-defeating in terms of the requirements of the OECD, because one of their requirements was to require us to increase capacity in terms of prosecutors, in terms of investigators, and all other necessary capacity. Now, after he left, what we did was to ensure, as a means of ensuring that we empower every prosecutor at every level, not only the SCCU, because these cases might not be detected as commercial crime cases dealt with by the SCCU. They could be detected by the prosecutor in Mkanduli, for example, just for argument's sake. It could be any office of the DPP. Our idea was that let's assign prosecutors, more especially in the SCCU, each prosecutor, there must be an assigned prosecutor in each region to deal with these cases, more especially once detected, we're able to fast-track the investigation so that we go beyond only preliminary. By 2018, for example, as I've mentioned in my report, it was because of exactly that. We're able to show, because these cases now, each one had its own prosecutor assigned. So it was easy now for that prosecutor to ensure that enough attention is given to that case. So that was what saved us in 2018 with the OECD. They could see that we're able to show considerable progress, because most of the cases now have gone beyond preliminary. They are actual investigation. If you talk of prosecution, that is a difficult problem for all major countries who are part of the OECD family. Even the United States of America, which is rated, and the UK.
I accept it's difficult.
Yeah.
As a country, we've not had one successful prosecution in respect of foreign bribes to date.
Absolutely.
Can I also say this, and I'm now going to tread into hearsay, but I'm sure Advocate Rip is going to indulge me a minute here. One of the theories as to why we did not get lambasted at the OECD was what they call Ramaphosa-phoria at the time.
Unfortunately, like the OECD, we present cases in terms of progress. You see, one of our problems with our cases has always been we were shortchanging ourselves in terms of reporting. Because when you report at the OECD, you report in terms of each step of investigation. What we wanted to do, we wanted to show a result. We don't want to give those details. So one of the issues that helped us this time, we're able to say, we instituted this investigation, we detected this investigation. As a result of that, this is the case plan that we have developed around this investigation. These are the steps. We have issued Section 205 subpoenas to the bank. We have issued Section 236 statements in terms of the criminal, all those processes. So we detail them and also give the result of each step. So that helped us a lot. The reason for that is because those prosecutors that we have decided to assign were able to devote time to say, for example, if I issued 236 statement, that is in respect of bank statements. These are the bank statements that were received. These are the results. Mutual legal assistance is a tedious process. You must be able to say, we have prepared an application for mutual legal assistance, for example. We give all that, we were able to give that detail. So that was a saving grace as well. And the fact that we're on the verge of having a prosecution was taking us a step higher. The reason for that, we have a dedicated prosecutor who was dealing with that matter, who are about to take for prosecution. So spreading resources, ensuring everybody is empowered, everybody, as OECD required, resources, you know, so we managed to ensure that at least enough and adequate resources and attention is given. That's what saved us. We are in a better than most countries now.
I've got to put 3 further submissions to you. Can you go to folder J number 170? You will recall that the debate with McAdam by your counsel was, and I actually can't remember if you dealt with it indirect, was the report to which you had changed, which was provided in Paris in 2015, and it was put to Advocate McAdam at the time that this report was hand-delivered. He was expected to comment, and you had anticipated that that department would comment and the report would be finalized. Do you recall that was put to Advocate McAdam at the time?
Yes, I recall.
I'm sure if I've encapsulated it wrongly, Advocate Rip would very quickly correct me. But I've been provided, which you'll see at 170 on the Dropbox, with a chain of communication which ensued in respect of the report. And I want you to just quickly flip. No, that's only one. Sorry, okay. You got an email request on the 1st of December, which is 170.2, with a copy of McAdam's report, and then in an email, go up, you indicate to them that I've got it, it's 170.11, where you respond at 22 minutes past 2 in the afternoon, where you indicate to Mr. Hogenraad Vermaak that the report will be submitted tomorrow.
Advocate, but we don't have what's the VT?
I think I recall that.
He sends you the draft report and you send him back and you tell him, I'll give it to you tomorrow. You then respond in an email, and I'm hoping the chain goes down. No, it's been put in a singular documents. Let my junior just find it quickly. Same day. That one. It's 170.13. You respond in an email at 170.13 on the 1st at 8:15 in the evening. Hi, Doc. I take it Doc is Dr. Hogenraad Vermaak. The status of each matter has been indicated in red below each case in Advocate McAdam's report. Other cases have been added for information. And he responds. He then has a communication with Govender. Or to now, it will also be on the 1st and 2nd. Let me just pick up the email quickly. My apologies for trying to do this. You then provide him with the report. He then sends the report on to Mr. Govender. Mr. Govender was the head of the department, correct?
Correct.
All right. He sends it to him at about he sends it to him in the next afternoon of the 2nd, here with the report. I will quickly peruse and forward it to the OECD. I see they already distributed a room document for the tour de table. And then the secretary to Govender queries it the following day, is it correct to show December 2014? And so I'm putting to you, Advocate Mokgoro, that based on the chain of email, the report was submitted via email to Hooggenraad vermaak, and that the recipients of those reports did not understand it to be a draft report.
I think Advocate Bauer, in my evidence, I explained the process just briefly in terms of how those reports are compiled before presentation to the OECD. You get information from all stakeholders, from the Hawks, the police, from the NPA, from the asset forfeiture unit, and that information is given to Dr. Hooggenraad because he is in the Department of Public Service and Administration. They are the department in charge of the logistics as far as the OECD matters are concerned. Then they would prepare, based on all those inputs, including my inputs which were in red, they would include them into one document, which will be a report to the OECD. That once that draft document is ready, it does not go to the OECD first. It must go to the Interministerial Committee, ICMC, Interministerial Committee. Now that I've forgotten the terms there, but it's an interministerial committee that must then look into the report and see that it accords, they agree with it. Once the report is approved, it will be that report approved at ministerial level that will be presented to the OECD, not the report with a draft read things.
Mr. Mokgoro, it's like country reports.
It's a country report. It's a country report. A country report cannot go without approval from the country itself as represented by the relevant, by the ministers concerned.
You certainly didn't go to Paris. That
I did.
in that period of time with a ministerial report approving that, because there was an altercation in Paris where Mr. Govender was very upset.
No, let me tell you the altercation in Paris. The altercation in Paris was that we are still reporting the same status in terms of how far, because those red indications that I did at home before we went to Paris were showing, in a sense, that we have not progressed in terms of our investigations. The question was, as the report now has been incorporated into the country report, how do we deal with this? I said, guys, the reality is that this is where we are. Let us rather explain ourselves to the OECD plenary. So that was the altercation was about that.
Let me, there's two things I need you to give your comment on, and then I want to deal with what is before the inquiry from you. You had explained to us the context of the Jacob report and your position in respect of that report. In paragraph 31, 32, Judge Jacob draws certain conclusions in relation to you, in respect of which you did not have an opportunity to respond to before Judge Jacob. Now, I can take the position that you do deal with those allegations in your affidavits in other matters, but I want you to have an opportunity to answer in respect of those. That report is at page, it's in folder F number 1.2, 1.2. I would like you to just read it there.
Must I read it aloud?
I was trying to avoid mischief making by not reading it aloud, but giving you an opportunity to comment.
I just wanted to make sure.
Can we accept, Advocate Bauer, that we don't have to go and get a comment from 32A? We've already dealt extensively with it. Paragraph 32A.
So you want my comment on that?
On 31, probably,
I was just trying to short circuit that 32A we've dealt with.
we've dealt with 32A. His conclusions in 31 and his conclusions in 32B. Advocate Mokgoro, I accept that you've dealt with this in affidavits, but I don't want to preempt your answer.
I think I would rather stick with what I've said in my affidavit.
Then yesterday we were provided with a judgment which I will say I did not know existed. And I don't know if you knew it was existed.
I would want that to be identified. If this judgment that I was given yesterday, I was going to object seriously to dealing with that judgment. For the simple reason. These allegations made in this judgment were made, it could have been some time, I can't remember. They were brought to my attention. I was surprised and shocked that it is alleged that I made this. I said I want a transcript because anything attributed to me in that fashion, in that judgment, it's definitely not something that unless you can prove the correctness of the transcript, because I believe, because this matter related to the prosecution in relation to confidential funds. And unfortunately, let me say it, a lot of things during that prosecution, a lot of uncomfortable things happened during that time, which I don't need to go to, which involve manipulation of processes, and it made us very suspicious that these allegations could be as a result of that man, unless you can first prove the correctness of the transcript first before I can respond to that.
Advocate Mokgoro, I'm going to propose we deal with it as follows. We got this judgment yesterday.
Yeah.
We got this judgment in the context of it was provided to us by Mr. Ladwaba, who's the
Yes,
appellant in this judgment.
Yes.
Consequence on certain submissions which you had made to the inquiry yesterday morning, which he had
Yes,
placed in dispute. Pursuant to that, he provided us with a judgment. When did you become aware of this judgment?
I don't know, after it was said that, because he was convicted in the magistrate court, I know that he appealed. I think it was after the appeal was...
The judgment is dated 8th January 2018. On the
2018, that's also very, very strange, because I understand it could, because I heard about this, that I heard some time ago that he took his matter on appeal and he was successful. Is it January 2018?
It's a year ago.
It's a year
So,
ago.
so it's two.
But it feels so distant with me, I don't know.
So it's a two-bench judgment of Karls and Peterson.
I just saw it yesterday.
It
So
was
you-
heard
you-
on the 8th
you
of
saw the
December
judgment?
2017.
Did you say you saw the judgment?
I saw it yesterday.
So you have, and you have read it?
I have read the judgment and
Okay,
that
thank
is
you,
why
that's
I'm
all I
so- I'm
needed to
ready.
know.
Sorry, but you're making a different point. You're saying it's strange that it's dated January. You would have thought it was further back.
Chairperson, 2019, I think it's just January this year, it's a year ago. It could have been beginning of the year, possible. I was a bit confused in terms of time.
I just needed to know if you've read the judgment.
Yes, I read it.
Yes, thank you.
See, Advocate Mokgoro, I'm going to suggest there is likely to be a transcript. We have been provided with an excerpt, but understandably, we've not looked at it. So I'm going to suggest we're going to give you what we got, and that it can't be ignored in the context of this is a judgment in which certain findings are made against you.
Yeah.
And it falls in almost some way squarely within the same kind of thing of the terms of reference of this inquiry. Do you accept that is the difficulty as evidence leader that I sit with?
Definitely, but I think let me make the task easy. Let me rather not object. Let's deal with the matter.
No, my preference, Mr. Mokgoro, would be the suggestion that is made. You read the judgment, you read the transcript, and then you respond to it. Because if you don't even recall the transcript and what was said in the transcript, it's not helpful to us,
Yes,
for us,
absolutely.
and it's not fair to you.
So I wanted to put in the suggestion that once we get that to you, that we give you an opportunity to put the written submission in on that. Because I don't know how to deal with it. I haven't read the written submissions, but I don't think we can take in the judgment without an answer.
That's acceptable, Chairperson.
Then the other thing that I would,
To the both of you, it might not be acceptable to us. Let's just have that caveat.
we would
I
need to,
just need to ensure that Mr. Mokgoro either agrees or disagrees that the transcript is a true reflection of what stands in the judgment. And that is why I asked you if you've read the judgment, because you seem to object to the contents of the transcript.
Listen, I'm objecting to the transcript of the original judgment appealed
Yes.
against, the
That's-
judgment in the
yeah.
magistrate court.
You object to the contents of the
Yes.
transcript, which is,
Yes,
which Ms. Bauer says is what stands in the judgment.
yes.
Ms. Bauer says, I haven't looked at it.
Or you haven't looked at it. But you want to match these two,
Yes, Chairperson, that was
Yes.
my idea,
yeah.
but yes, that is,
So you must read both if you want to match them.
yes.
Yes, thank you.
This is the transcript of the proceedings in the match
In
court.
the match court, yes.
In the appeal, they get the transcript and they make judgments reflecting what was said in the, so it would be acceptable to you if the appeal record, because it will contain, the record contains what happened in the magistrate's court.
At the same time, Chairperson, I also would want to listen to the tape recordings.
So what you need to do, what you want to do, is to listen to the recordings in order to match the transcript with the recordings.
Yes, Chairperson, because I suspect a lot of things have gone wrong, could possibly have gone wrong, because I know the history of this matter.
Over to you, Ms. Bauer.
Before that, I really want to understand what Mr. Mokgoro is trying to say. Are you saying that the judges in the matter, something may have happened there, something may have happened in the magistrate's court, something may have happened during the transcription of the record? What are you saying?
My suspicion is during the transcription process. That's where my concern is.
You suspect there was some distortion.
I would be able to tell some of these things in camera, but I would not be able to. But I suspect there could be, in the transcription process, I have, because some of the things I heard, I was said, I cannot even remember. How do I remember? I mean, I could not associate myself with some of the things mentioned there. In any event, it's not a long thing.
You want to say something? Ms. Bauer?
So I can make a transcript available because that's what I have. I don't, I'm from Cape Town. I understand the efficiencies that we have in Cape Town doesn't always work as well in Gauteng. I don't even begin to know how we go about getting a recording of a magistrate's court somewhere. I will delegate my junior year to ascertain how feasible that is within the time constraints of the inquiry. That's the best I can do, but I can hand the transcript over today.
And then what will you make of the subsequent cross in that regard?
No, I have a judgment that makes certain findings. I'm put to Advocate Mokgoro that I can make a transcript available for him to put his position to the presiding officers. If we can't get a transcript and he disputes what is contained therein, then the weight of it must be determined by the presiding officers. I can't certainly take it any further. We have not investigated this matter. We have not spoken to anybody. It may never have come to our attention, but for one question that arose yesterday.
Mr. Rib, what is your take on this situation?
Ma'am, obviously, we haven't discussed with our client. The judgment was given to both Advocate Mokgoro and ourselves at the close of proceedings yesterday afternoon. We didn't discuss with our client because he's under cross-examination. So the first time we've become aware of his position is now. So I'm quite happy with what Advocate Bawa has suggested, that she maybe hold over any cross-examination or till we've had a chance to see if we can find the. I don't want to. Do you just want to hold over?
I'm not going to cross-examine on it. I don't have any knowledge to cross-examine on it. I'm suggesting there's a position. He must give his version to the presiding officers.
We'll see then if we can if we can obtain a recording, and if anyone can obtain the recording in the time, and we will do then written submissions, hopefully obviously before or by Wednesday next week, so it can be incorporated in the submission part of the proceedings. I think that's the best we can do, but we will respond to it. I will take it up with Advocate Mokgoro, and obviously we need to respond to it and deal with specifically the findings.
Then let me, for the sake of...
I think we would probably agree with that. Yeah.
And then finally, let me come to the question on Busasa. We as evidence leaders find ourselves in the same position. You had provided to us a number of documentation. We can neither confirm, dispute, and we have not had an opportunity to investigate it. And so what is before this inquiry is the evidence that had been put before the inquiry was obtained from the State Capture Commission, and what you have put before the inquiry. And as evidence leaders, we don't take that any further. I have no further questions.
Ms. Ms. Bauer, there's one question.
Maybe to you or to you, Mr. Mokgoro, if you know that, I can't recall, when was the magistrate's court matter done?
July 2015, says my junior. Pretoria Regional SCCU. So,
because I take it, Mr. Mokgoro, you do know that there might be issues about retrieving that record, because I don't know about the magistrate's court, but with the high courts, we changed the recording. Companies were changed. You can't get records. It might just be an impossible task.
Chairperson, I will discuss with my lawyers. Maybe we could adopt a different approach.
Usually we say it's impossible after we've tried. There might be difficulty. I think let's just try. If we can't get it, we'll let you know. Ms. Bauer, are you done? Yeah,
Can we then
Can
leave
I-
it that Advocate Mokgwebi's attorneys will follow up?
yes. We have that undertaking, Mr. Rip.
Yes, ma'am.
Yes, thank you. Mr. Mokgwebi, can I just take you back a little, if I may, to the description of, I think it might have been about your annual reports, the NPA annual reports. You said you reported to Parliament at some stage about, what was it in your annual report that you reported about the statistics and the kind of misleading situation of your stats, the difficulties that you experience with regard to the statistics that you report, that you present to Parliament. You remember you said something to the effect that when you have to report about your stats of crime or case resolutions or case the dealings with your cases, sometimes as the anti-corruption task team or ECTT, you had particular difficulties and you end up with providing misleading statistics because the information would not be quite accurate. In other words, the details of the cases would give the impression that your stats are at a particular level, but it does not give the full circumstances of the difficulties that you experience. What was that about?
Chairperson, I am trying to,
You're trying to recall.
recall.
Yes.
But I think my reference to report to Parliament, it was in the context when I was talking about the issues that surround the DSO. The only one I can recall for now, except the mention of the ACTT, I had stated that when I was giving evidence or I was being asked about my experiences, things like that, I mentioned one of the issues that we identified that would have led to the downfall of the Scorpions was our information that were reported to Parliament, for example, in terms of matters that we would have said fell within the mandate of the DSO. I think I mentioned something to the effect that the problem started then because it became clear that we're not doing, strictly speaking, the work within the mandate, but we're doing the police work. That's what led to the differences, to the fights between ourselves and the police, because the DSO was established with a particular mandate to deal with priority matters of national importance, but we ended up dealing with your ordinary fraud matters, your identity theft cases, your 419 scams, and all your petty fraud, your road accident fund frauds, your SASSA grant frauds, you know. So those were called our bread and butter issues. So this is what I'm saying, was misleading in a sense. And that's what caused the difference, the fight.
You and the police?
Yes.
Okay.
Yes.
Yeah, thank you. I just needed clarification about that. Thank you. Mr. Rip?
Ma'am, before we start the examination, could we have just a 10-minute break so I can,
I'm sure that's
between
no problem.
5 and 10?
That shouldn't be a problem. It depends how long you're going to be when you
I
come
don't
back.
think
I don't
we're go-
want to limit you, but
I don't think we're going to
I
be
just need to
terribly
know how
long.
long you're going to be when you come
I
back.
don't think more than 20 minutes probably.
okay.
I just want you to clarify something with my client before I take him through certain aspects. Thank you, ma'am.
I think we can do that. How long? 10 minutes?
It might be less, but I will, not more than 10 minutes, at maximum 10 minutes.
Lajes, 10 minutes, outer limit.
Absolutely. Thank you,
you.
ma'am.
Thank you. Mr. Rep?
Thank you, ma'am. Advocate Mokgoro, just a few questions to, I think, wrap things up. The first is, you've been under cross-examination for more than a day now, and there's been a lot of debate about exactly what should or should not have been part of your decision to provisionally withdraw the charges against General Madluli. You recall that debate?
Yes, I do, Chairperson.
And you heard Advocate Jiba yesterday speaking about the independence of the prosecutorial office.
Quite correct, Chairperson.
What do you think would be the effect of, in the National Prosecuting Authority, if every time a decision was taken in respect of a prosecution that certain other members in high management didn't agree with, we ended up with an inquiry of this nature and an investigation of this intensity into such decision?
Naturally, Chairperson, the effect would be very chilling. It would be counterproductive. It will be against the spirit of the Constitution, the NPA Act, which requires to proceed without fear, favor, or prejudice. It will be definitely devastating. It will be definitely damning.
You had a debate with Advocate Bauer about the confidentiality of documents and the intelligence. And one of the debates surrounded the charge of receiving a gratification by General Madluli because of the loan agreement. Do you recall that?
I do, Chairperson.
In case it's necessary to remember this, Advocate Bauer put to you a few times that on the probabilities, it's clear that the car must have belonged to General Madluli and he must have received a gratification. You recall that?
I do, Chairperson.
What is the test in a criminal matter for a conviction?
The test in a criminal matter is proof beyond reasonable doubt. Evidence must exist that proves a fact beyond reasonable doubt.
And unlike in a civil matter, must the accused person give evidence? Does he need to come and explain himself? Must he come and explain a negative?
In a criminal matter, the accused does not have to do anything. The accused does not have to explain himself, does not have to do anything. Only the state must gather all evidence that is necessary to prove all elements of the crime beyond reasonable doubt.
And you on a number of occasions referred in answers to questions that the gratification must be unauthorized. Who must prove that the gratification was unauthorized?
The state must have evidence to prove that fact. That evidence must be in the docket, must be the result of investigations by the investigating team.
Would the accused have to prove he was authorized?
The accused doesn't have to do anything. He doesn't have to do anything.
So what just assist the panel in understanding what you perceive the dilemma to be with crime intelligence and proving that it was unauthorized?
One of the first things that one has to determine was whether indeed there was gratification. If it's proven that there is a gratification, whether that gratification was unauthorized, it may well be that it was authorized, in which case the state must have that evidence as part of its evidence. If it was not authorized, the state must have that evidence as part of its evidence in the docket. A number of issues, or a couple of issues, are triggered immediately you put that type of a charge. Was there authorization? who's supposed to grant that authorization, proof of that authorization. It may well be that in certain instances, people are exempted from getting authorization for receipt of gratification. That evidence must be in the docket. It may well be that in terms of your regulations, your policies, what is required is disclosure. Disclosure may be enough. Now, for you to prove disclosure, it means you must go to the policies of the organization concerned. You must understand the policies of the organization concerned. You must go to the personal files and the relevant files within that particular institution. So that evidence should have been there in the docket. You must also further prove, as Advocate Ferreira has said, Mdluli must have known because there were 60 million worth of transactions entered by SABC. That evidence should have been in the docket. That evidence is one of the pieces of information that would be helping you to prove, to build your case beyond reasonable doubt.
When the decision was taken on the 9th of December between yourself, Advocate Manzaniati, and Advocate Breitenbach, that there would be a provisional withdrawal of the charges and a further investigation, who were the prosecutors on the matter at the time?
The prosecutor that I knew in the matter was Advocate Smith.
And who else was assisting him, can you recall?
I knew Advocate Breitenbach was the supervisor, but later on I saw Advocate Ferreira coming into the picture, like the time when they would come and deliver those memoranda.
And I recall from the evidence of Advocate Breitenbach that Advocate Smith was a very experienced senior prosecutor.
Yes, I understand so as well.
The suggestion to you was made that you somehow colluded in the suspension of Advocate Breitenbach. What do you say to that?
I deny that. I did not take any decision in that regard.
And that such suspension was to prevent the further prosecution of Advocate Mdluli, the suggestion would appear.
I strongly deny that.
In fact, she wasn't the prosecutor.
She was not a prosecutor in any event.
Did you, Advocate Mokgoro, at any time take any active step to stop the prosecution of General Mdluli?
No, sir. No, Chairperson.
In fact, in the representations which were shown to you today, attached to the attorney letter, you'll recall those representations that were handed up to you today?
Yes, I recall.
In fact, those policemen were complaining, at least in February, that the prosecution or the investigation was continuing unabashed or unabated.
I recall that.
So you hadn't stopped the investigation in any manner?
I did not stop that investigation. I was not involved in that investigation.
Just insofar as it's necessary, the difference in the position between the prosecutor and the investigating officer or officers on a matter at that time, who was doing the actual investigation?
The investigation is a police function. The prosecutors are there merely to guide. Once the investigators have procured evidence, they would have to come to the press to say whether it advances the case that is being investigated in question, to guide the investigation in terms of quality and the nature of the evidence.
At the commencement of proceedings this morning, you were a bit agitated, obviously thinking about things overnight, and you wanted to bring certain reports to the attention of the inquiry, because you felt it very unfair that you were told that there were 7 or 8 to 1 decisions. Would you like to just take the inquiry through the reports? I'm not sure where they are found, but we all know which documents they are. Perhaps if you could assist me. We handed in a bundle earlier that it is common cause. Madam Chair, they are in the Dropbox and all part of the papers. But perhaps you could just refer to those portions that you wish to refer to.
They to be found in folder 155, but if Advocate Mkhwebi gives us the date, then we could link it up quickly.
Okay, so Advocate Mkhwebi, if you could just give the date of the specific report you're dealing with on each occasion, and then I'm certain
Yes.
the researcher could assist us with putting that on the screen. Thank you.
Yes, thank you, Chairperson. The first report I just want to refer to, Chairperson, is the report dated 27 November 2012. It's a report to Advocate Mokgatle, the acting regional head at the time. It's a report from Advocate K. Mashamaite. The report consists of about 14 pages, but for the purposes of this matter, I will only refer to a few portions of the report. The report deals with the status of the investigation with regard to the Mdluli matter under Silverton CAS 15507-2011, insofar as it relates to the purchase of the BMW 3 Series and the 5 Series BMW and the trade-in of the vehicle of Mr. Mdluli. The prosecutor analyzes the evidence in this report, and in page 2 of that report, the prosecutor refers to the summary or to the witnesses who are relevant in this matter, and summarizes them up to page, I think page 6. In his summary, the prosecutor also states the concerns that it's a report from Advocate Mashamaite. Advocate Mashamaite is one of the prosecutors that were appointed by Advocate Mokgatla after the meeting with General Dramat on the 1st of August 2012. After that summary and concerns about the evidence of the witnesses, he concludes with possible charges that may be leveled against Mdluli. For example, he says the possibility is that we could have a fraud or theft charge in relation to an amount of 42,313 in relation to a discount and trading assistance. But he continues to say, this will, however, depend on consultation with Mr. Fesser clarifying this deal to us. We still need to look at the evidence to establish if Mdluli had knowledge of this deal and or whether Mdluli was acting with common purpose with Barnett, his co-accused. Now, he says the second count we may possibly have against Mdluli is in respect of theft or fraud in respect of the amount of 31,500 in respect of the discount on the 5 Series BMW. We need to establish, however, if Mdluli had knowledge of this payment, which payment was made to Atlantis Nissan by Leo Hase BMW to the credit of his loan account with Atlantic Nissan. Furthermore, we need to determine whether Mdluli acted with common purpose with Barnett in respect of this deal/transaction. The third count that was possible at that stage is a count of corruption against Mdluli in respect of the amount of 48,313 in respect of the loan that he received from Atlantis Nissan. Now he says, the prosecutor says, however here, we need to determine whether Mdluli influenced and or gained the loan in a corrupt manner, in particular when he said at some point to Mr. Fenter that he will take care of him. So effectively, the prosecutor is actually saying there are still issues that need to be determined before any charges can be leveled. Then I just go to the second short report, Chairperson.
What's the date of that report?
I'm just going to go there quickly. It's a report dated 27 June 2014. This report comes from Advocate C.M. Viljoen. Also, Advocate is dated 27 June is in respect of the state versus Mdluli and others. The prosecutor here deals with the matter in respect of the loan of 50,000 that Mr. Mdluli allegedly got from Atlantis Nissan. Now, what he says, the prosecutor in paragraph 2 of that letter, he says, when the matter was withdrawn, it became known to the investigating team that Venter did not tell the truth. Mdluli never approached him. All and any dealings with regard to these transactions was with Barnett from UTE. Now, in paragraph 8, the prosecutor deals with subsequent events. He says in paragraph 8, the investigating team under the leadership of Colonel Rolofse informed me, that is me, Advocate Rita Viljoen, informed me of the so-called kitty held at Nissan, Atlantis Nissan. In paragraph 9, he says, this kitty was referred to in Nissan's book as the Barut account. The investigating officers indicated that the 50,000 check from Nissan to BMW was paid from the Barut account. In order to complete the picture, it became necessary to establish who the owner possessors of the Barut account was. Venter, our less than truthful witness, could not be relied on to give us the correct information. The internal bookkeeper could not assist either. We were forced to turn to a forensic auditor for assistance. The crime intelligence is refusing access to relevant information, which leaves the long route in tracing the deposit. That's paragraph 16. Back to, sorry, if I may start, crime intelligence agency, I would assume, is refusing access to relevant information, which leaves the long route in tracing the deposits to Barut. Back to specific transactions between Nissan and UTE. Now I go to paragraph 17. Exclusive reliance must now be made on records obtained from Nissan for the period 2008 to 2009. This entailed having to sift through transactions between Nissan and UTE totaling almost 40 million. Although not completed, paragraph 19, although not completed, the forensic auditor is willing to at least provisionally indicate that money was stolen from UTE and Nissan. The money so stolen was transferred to the Barut account held in Nissan's books. The Barut account has been found to be a client account with constant credit balance, in other words, Barut money. Now we have to establish who Barut is. Now, under paragraph 23 is about further investigations of the matter. Now it says, paragraph 23, after receipt of the forensic report, the investigating team can follow up on the findings and take the necessary witness statements. Paragraph 24, it says, at least then the forensic report will corroborate what the witnesses are saying, especially Mr. Venter. Venter and the bookkeeper will have to be approached to establish who Barut was. It is firmly believed that Venter will confirm that it was created for Barnett. It is furthermore our expectation that Venter will confirm that Barut account was controlled by Barnett. Now the prosecutor comes to the evaluation of the evidence to say, paragraph 28, should the completed investigation show the above to be true, one is left with a question of how this evidence relates to Mdluli. Should one be left with the evidence that shows Barnard, with the knowledge of Lazarus, arranged for the check of 50,000 to be paid to BMW from Barut account, it means it was paid from the stolen kitty. The significance of this significance being that Nissan did not corrupt Mdluli, or for that matter, pay anything. Barut, i.e. Barnard, did. If this is the evidence, the way forward is less than clear. Normally, one would prosecute the receiver of stolen goods together with the thief. The thieves are being prosecuted by Gerinel in another case. So that is the report of the prosecutor on the 26th of June. The last report, Chairperson, that I want to refer to is the report again from Advocate Rita Viljoen, dated the 26th of August 2013, in respect of the investigation of this matter. She says, the main witnesses in this investigation are Mr. Nicholas Venter, the sales executive of Leo Hase BMW Pretoria, and Mr. Jan Venter of Atlantis Nissan. It has been impossible thus to consult with Mr. Venter, as his advocate is apparently not available till sometime 20 September 2013. Mr. Venter revised statement is still being awaited for the same reason. The chief investigator, Rulofse, is in Pretoria this week in attempt to sort this out. Any discussions about this phase of the investigation is mere speculation. It is impossible without proper A1 statement to even suggest a way forward. An A1 statement is the first statement in the docket, which is usually the complaint statement. So, Chairperson, those are the three reports that I thought I need to place on record as I requested. Thank you very much.
Thank you. Then the ACTT.
Can I understand,
Sorry, ma'am.
Mr. Rib? We've had a discussion of these statements in this inquiry. What I'm trying to understand is, at the beginning of the inquiry this morning, you were quite upset, and I'm still not sure why, because we had these statements before us.
Yes. The inquiry had these statements before us. But when the evidence under cross-examination was led, I was under cross-examination, the situation, in a sense, was left hanging. That was my point. It was as if, because there were 7 people against 1. So that is the end of the matter. So I wanted to say, let's have a balance. To say, despite that, we still have this evidence. These statements were here, but they were not. They were referred to, not necessarily that there was any particular reference to details of what each contains. That was my point, Chairperson.
Thank you, ma'am. The ACTT, the Anti-Corruption Task Team, is a combination of different interest groups. Could you perhaps just briefly and quickly as you can tell us who all makes up the ACTT?
Yes, just quickly. Thank you, Chairperson. As I've mentioned initially, the idea was a kind of a replacement for the Scorpions. The ACTT is an institution that is established between various stakeholders in the criminal justice system. It consists of the NPA, it consists of the Hawks, it consists of the SIU, it consists of National Treasury, it consists of SARS, it consists of the FIC, Financial Intelligence Center, It also consists of a number of other government institutional support services like your state security services. So the idea of that is that that organization's role, mandate, is to deal with matters of serious corruption, high-profile cases. Its mandate is to deal with those crimes or those serious cases of corruption with a value beyond at least beyond 5 million and above. So it is controlled at a central level. It consists of prosecutors there whose role is to guide any investigations that have to be referred to the ACTT, like your POSASA, for example, was referred to the ACTT as a project, which was going to be managed at that level by a combination of members who belong or who compose of that organization.
And obviously,
Just a question on that. So the ACTT, under which institution does it fall? And is it under NPA? I mean, because you say it's made up of all these parts from different state institutions, you know, but who has overall control over that?
The ACTT is controlled by all these organizations in terms of a structure called the principals meeting or the executive committee meeting, which is called the principals, because all those heads of those institutions that are part of that would constitute the management or the executive structure of that. And below that is what is called the operational management. It's where now the cases are received, are determined whether they fall within the mandate, and those cases that have been received, are they receiving the necessary attention? Are there any issues that need to be addressed in terms of resources, in terms of progress of those investigations?
if I can just take a little further, it's a multi-government organization team.
Yes, it's a multidisciplinary organization structure.
And no one department or no one group within the team controls the team exclusively. It has to be done by agreement.
Absolutely, absolutely.
So it's a bit of an unwieldy body, actually.
It is, yes. It's a very unwieldy body. It's very difficult to manage because the disparate interests, of course.
There is no chief there.
Strictly speaking,
Too many chiefs.
Chairperson, there is no chief. There is no chief. All of them are chiefs.
Now one of the...
Sorry, Mr. It is just, it deals with operational issues.
Chairperson, it does not still deal with strategic issues as well, because
okay.
the issue is, it's an oversight body at that level of the executive committee. The operational level is a body below where the actual cases are being monitored. So if there are issues with the cases, we report to the structure to say there are problems, no resources, whatever. We ask for your intervention in this regard or in this regard.
So they have an operational team which reports to the strategic team.
To the principal, the strategic team, so to say, yes.
And just to place the panel insofar as it's necessary in the picture, the DSO or the Scorpions, one of the reasons why it was so effective was that prosecutors and investigators from the police work together as one team.
That is quite correct. We had prosecutors, investigators in one team. We also had a limited intelligence gathering capacity, of course, limited to open sources, not.
Yes. So when that closed, and by 2011, when you took your decision, Inspector General Madluli, it was back to how it had been traditionally. The police did the investigation, they gave the evidence to the prosecutors, and the prosecutors did with it what they could, or asked for more evidence, or gave some guidance perhaps, but it was run under two separate heads, actually.
Yes.
So it wasn't up to any prosecutor to go and find evidence from 20, or from when the Scorpions died. It became solely the investigative powers lay with the police.
The investigating powers lay solely with the police, unlike in the position with the Scorpions before.
Yes. You'll recall that you gave evidence about a threat of a media backlash, and there's also a note, would appear to be a contemporaneous note on one of the documents presented to you today, made by Advocate Breitenbach.
Yes, indeed, sir.
Okay. Did such a backlash, media backlash, then ensue?
That backlash indeed ensued. It started during a march, started gathering momentum. We started hearing accusations of interference in this case, in that case. Also, it was for the first time that we heard about the story of a letter written by Mdluli in April, to be exact. That's when the news about that actually hit the headlines, and we were, the media started indeed to be on in our case, so to say.
Now, this was, I think, one of the last questions. You'll recall that you were given the option to take part in the Yaqub fact-finding committee, I think very fairly in a letter that we've dealt with, and you elected not to take part because of the difficult circumstances that we've dealt with before. You recall that?
Yes, I do.
Notwithstanding that, Mr. Hofmeyer said you refused to participate in circumstances where it appeared that he felt you had an obligation to participate, and your office was cleared out and even your safe eventually cut open. How do you feel about that reaction?
I don't know how to say it. It was one of the traumatic experiences. It was one of the traumatic experiences, as I said in my evidence. You know, it became very clear to me the idea was actually to provoke me to some form of action. But I think I've learned the art of forgiveness. I decided, let me just move out of this situation. Let me forgive these people, go home and pray, come back. And I later embraced them.
You, I think since you're a man, I don't think this is too terrible, but in January this year you turned 60, and in fact your entire working career you've been a prosecutor and associated with the prosecutorial services of this country.
That's correct.
What's your final word on the suggestion that you're not fit and proper to occupy your position?
I find that, to be a bit insulting. I find that to be a bit insulting because I would say, whatever the views of other people, my idea has always been to safeguard the integrity of the organization. I've went through the worst in this organization. The question is, why did you not leave? I still believed that I still owe this country a sense of gratitude. So any allegation that I am unfit, to me, I feel completely shattered.
Thank you, ma'am. With no further questions in your examination.
Thank you, Mr. Rep.
Happily, we have no questions for Mr.
Okay, thank you. So you're looking at me with big eyes. Okay, thank you, Mr. Rep, and thank you so much, Mr. Mokgoro, with your legal assistant. We appreciate your participation, okay?
Thank you, Chairperson.
You may be excused, Mr. Mokgoro. because we want to deal with in-house issues now. You still enjoyed it. You can come back. You can come back if you want to. Yes.
Advocate
Ms.
Jiba
Bauer?
says you can take it.
Yeah, I think so. She didn't hear that. Yeah, no, Jiba can take on.
Can we start at
Can we-
9:30 on Monday?
Agreed. 9:30? 9:30.
We will,
9:30 on Monday. Okay, thank you, everybody, and
Judge, do you want to just deal with housekeeping for the rest of the week next week?
I prefer day by day.
Okay.
We have a schedule, okay?
We've changed it a bit, that's why I
Then you've got to do it in writing and circulate it.
we're gonna run everything on Tuesday.
I would actually have preferred Monday open and Tuesday, but what's done is done.
Sorry, but on Tuesday, there's nothing as far as the...
Yeah.
Unless she takes the whole day with cross-examining Advocate Chiba, and I take the whole day leading, re-examining her on Tuesday.
Which need probably not be the case. We're not sitting on Tuesday. Our
Well, but what-
schedule is open on Tuesday for
Okay.
other work.
Hopefully I'm just saying that she should take about 10 minutes in cross-examination so that we finish for Tuesday.
So that you can also take 10 minutes.
I'll take less time than they took with Willie Hofmeyer.
So you can take. Okay, thank you, everybody. Yeah. Have a good weekend. Those who are traveling, travel safely. Okay?
Including you, Chair.
Yes, including myself. Thank you.